Hello, everyone, and thank you for tuning in to the Love Where You Live show. I'm here today with one of the top probate and estate planning attorneys on the Central Coast. And whether you are a homeowner, a parent, or you simply want to protect your loved ones, this conversation could help you save tens of thousands of dollars when it comes to planning for your estate. So we're going to dive right into it. So Matt, tell us a little bit about yourself and what you do.
Owen, thanks for having me. My name is Matthew O'Leary. I am a trust and estates attorney, is what we usually say, which means I focus my entire practice on either planning, estate planning, which typically means planning for transition, meaning someone passes away, or someone needs help, or someone's trying to plan for that next stage of life. So we focus our practice on estate planning or probate and trust work. And so that might mean in-court work, which we'll probably talk about avoiding and why, or that might mean behind-the-scenes work through a trust or other entities, and why that might be a better fit for people.
Okay, cool. We've personally had the privilege of working with Matt, and he's worked with several of our clients as well in the past. He's done a fantastic job for us. Now, Matt, let me ask you this. What do you think is the biggest mistake that most families make when it comes to estate planning?
Well, probably the number one thing that, I don't know if it's a mistake, but a decision that people make that ends up perhaps setting their family back is that they think, I'll get around to this planning at some point, and it feels like it's either too scary or too difficult or too expensive to take advantage and do the plan while they can. And so they think, I'll get to it eventually, I'll do it next time, I'll do it next year, I'll do it next decade. And then before they know it, it's too late, and they're dealing with something where there's no clear plan or there's no plan at all. And now they're in a really tough spot. I would say that's probably the number one problem I see. The number two problem is probably a little bit more complex, and that's perhaps entrusting the wrong people in one's life, picking someone to help who's maybe just not able to help you or shouldn't be the person that would step in and help you if you needed help in your own affairs.
So let's say someone passed away tonight and they didn't have this plan that you're talking about set up.
Sure.
What happens to their loved ones tomorrow morning and their family?
Well, there's a lot of very important, very time-sensitive stuff that everyone has to deal with, no matter how great, no matter how impressive their estate plan was. There's just the normal personal stuff that you have to deal with. And there's nothing that we estate planning attorneys can really do to totally help with that. Obituaries and sock drawers and utility bills. How do we connect the dots with all of that? That's all really important, very pressing personal stuff that we can't help with. But what we can help with is this bigger things. So if someone passed away tonight and didn't do an estate plan at all, tomorrow their loved ones are going to be left with a lot of uncertainty and, unfortunately, with a lot of delay. They're going to have to find either the process or the right attorney to start an estate probate proceeding, and that's in the county where the person lived. And then there's going to be a waiting period of trying to get materials filed, and then waiting for the court to hear it, and then hoping that every little box and every little detail was done correctly. And then they're going to be set up for a whole bunch more waiting. And at the end of that, they're going to be set up usually for a pretty large attorney's fees bill, or perhaps just a bunch of court fees that come with the process, or maybe a big attorney's fees bill and a big bill to the personal representative of the estate. So they're set up with some uncertainty, and they're set up with some delay, unfortunately. And then with that, it's usually going to come a higher cost too.
So the costs of time and money.
Yeah.
What would you say is like the average someone could expect it taking as far as time goes?
Sure.
And how much do you think that could actually cost?
Sure. Well, here in San Luis Obispo County, I used to say it's about a year. And if you really hustle, maybe you get it done in 9 months. It's now more like a year and a half. And if you really hustle, you get it done in about a year. So you're looking at about a year-long delay full access to the estate of the loved one who passed away. And I used to describe it as a $50,000 experience, if on $1 million estate, which you think $1 million, that's a lot of money. But no, it's $1 million of gross value in your estate. And so that I used to describe as a single family home worth $750,000, even if it had a $600,000 mortgage on it, plus maybe a modest retirement or brokerage account, $250,000. That $1 million, really pretty simple estate is going to cost $23,000 to the attorney, $23,000 to the personal representative, and somewhere in the $4,000 to $6,000 of court costs and associated costs with a probate. Those numbers are now a little stale because, as you can guess, $750,000 is not a single family home anymore. So $750,000 should probably be bumped up to $1 million. And even if you have that big mortgage where the net value is only $100,000 or $200,000 or $300,000, you're going to pay the fees on the gross value. So it's a $50,000, $60,000, $70,000 experience, and it's a 1 to 1.5 year long delay.
That's pretty brutal. And so that's all because you didn't have a trust set up.
Yeah, you didn't have a trust. I mean, there's non-trust planning tools. Someone can do a deed for their house, which is called a beneficiary deed, that says when I pass away, it goes to my kids. But that only provides for your house. So typically it's still better to have a trust that encompasses all of your estate and make sure that you can do a holistic plan for everyone. And now the process is shorter, but then the cost is significantly less.
Wow. Now, when it comes to all this planning, is there something that could happen where you just lose your house? The family loses the property to this probate process, anything like that?
You do hear people say that sometimes.
What does that mean?
They say, gosh, I got to do something, or otherwise it's all just going to go to the state. Right. You hear that all the time. And even though that's a good sales pitch, it's not necessarily true. It doesn't really just go to the state of California. But the state of California does dictate then what should happen to it, who it should go to, who should be in charge of it. And then, of course, the cost and time delay we just said, how long it's going to take and how much the fees should be. So in that sense, it does go to the state. But to almost everybody, the vast majority of people, there are heirs, and that is the people who are your family members. Either your children or your children's children, your spouse and your children if you're married, your parents if you don't have any children, your siblings and their children if you don't have any parents. But from there, it starts to fracture out pretty wide. It goes into kind of a wide spider web of people. And those people might be people you care about. They might be close to you, but those aren't necessarily always your people who you think should step in. Maybe you have a significant other. Maybe you have a close family or close friends, I should say, people that you're close to that you would want to be involved. And they're not going to be the ones that the state says should be involved.
Yeah. One time, my wife's grandpa received a check in the mail from some long distant cousin he didn't even know existed, who died and had, I don't know how many degrees of separation, but somehow he gets this check in the mail for a huge chunk of money. He's like, wow, sweet. Thanks, cuz.
Brewster's Millions. Right? Yeah. It doesn't that's the dream scenario. It doesn't happen very often. It's usually more that somebody is, I have a new matter right now where the person was passing away, had been married for some time, had a child and a stepchild, had never updated their estate plan. And so now we're left in a situation where the new spouse isn't included in the documents. And so the state of California says, well, that new spouse is now entitled to a certain amount. And that amount is probably more than what our decedent, our person who passed away, our loved one, wanted. He wanted more to go to his kid and stepchild than he actually wanted to his very new spouse that he'd had for a year. So those are the kind of things that the state will prescribe to you if you don't take it into your own hands and write down your own plan.
And set it up.
Yeah.
Okay. What would you say are the biggest myths about the probate process?
The biggest myths. Well, about the probate process, Probably the biggest one is that the state is going to take all your money. It's not true. It's going to go through a process, and it's a pretty orderly process. So that's definitely one myth to dispel, to make people feel a little bit more at ease. One of the things that people think regarding trusts is that if they do one, they never have to pay taxes again, right? And so you see that online from time to time about what a tax shelter your trust will be. And that's dangerous information, because not paying your taxes is a crime, and you literally can go to jail for it.
Mm-hmm.
You can go to jail for even advising people not to pay their taxes. So that's one myth, that people think if they do an estate plan, they won't have to pay taxes anymore. So their estate plan can give flexibility regarding taxes. The estate plan could perhaps benefit your children regarding taxes, but there's still going to be taxes to be paid, unfortunately.
And there's lots of different types of taxes. So
Sure.
let's explore that a little bit, because I think there's a lot of misconceptions when it comes to taxes even. Because you've got your capital gains tax that people are concerned about. You've got your property taxes, which is also separate. And we use the word basis, property tax basis, to describe either your property tax basis, and even we use that same phrase for your capital gains tax basis. So there's confusion there.
Good point.
And then there's also the inheritance tax. So when it comes to tax planning, does an estate planning attorney help in any way with sheltering taxes legally and following a process to help their families set up something to prevent paying more tax?
Sure. A really great point. An attorney needs to be very upfront about whether they're giving advice relating to taxes or not. But yes, typical estate planning is going to have provisions regarding estate tax. The estate tax limit has gone up a great deal in the last 20 years. So it used to be a very relevant tax to many, many people. It's now a tax that's only applicable to a couple percentage points of people. It's $15 million per person. So a couple can have $30 million before they pay any estate tax. So I know that's many of your clients, but that's not everybody. So that is one thing that an attorney should be planning for and talking to you about in your estate plan. Regarding a capital gain basis, the important thing to know is, as an estate planning attorney, is that bases will change when something is inherited, but the capital gain basis may not change if it's gifted. And there's a whole dynamic about when a step up is coming and when it's not, and how to plan around that. So that's an important thing for attorneys to know. And then property taxes is definitely something important for your estate planning attorney to know, something important for you to know. But it's also a system that's changed quite a bit in the last 4 or 5 years with some new laws in the state of California. It used to be that you could inherit $1 million of assessed value of property from your parents and keep their property tax basis. And that changed in 2021. And so now you can inherit your parents' house or your parents' ranch, family farm, as long as you're going to live in it and they lived in it, and you can avoid getting a new property tax basis. All the rest of the real estate is going to be reassessed for property tax basis to a present value. And so that's something important for your estate planning attorney to know, your probate attorney to know, is if that's applicable in your situation, and then if it is, to make sure that forms are filed in a timely fashion, that personal residence is declared by the family within a year. So these are all important things to make sure that your estate planning attorney knows.
Mm-hmm. Yes, that does affect the buy and hold method.
Sure.
Where it used to be you could plan to pass your real estate, your investment property, to your heirs, and they would receive that same property tax basis that you had from the time when you acquired it. So you could pass down for generations and build wealth through real estate that way. And when they changed Prop 19, it almost is going to be triggering the sale of more property, breaking up that generational wealth and bringing it back to markets, which the reason why the California Association of Realtors did support this was to try to increase the inventory and try to get more property back on market. And so it's going to be painful for some people who have extremely low property tax bills of $400 a year, $500 a year, when all of a sudden it goes 10x, 20x to today's fair market value.
You make a good point, though, about increasing inventory. I was talking with somebody about it this weekend when we walked past a high-profile business downtown, long-time business. I won't say it, but it's been vacant for a handful of years now, not really being marketed for sale, even though it's for sale, not really being leased, just being completely unproductive, sitting downtown in a prime location. And that's because the family inherited it under the prior rules, with a very low property tax. It was mom and dad's store that's now in the hands of their heirs, but there's no real motivation to either sell it or to lease it because they're paying very little, and so it becomes this hold and wait situation, and that's really not productive for anyone. So I won't be too sad about more property moving, to be honest.
Mm-hmm. And then on the other component of this, the capital gains tax. So the way it works with capital gains tax, you buy a property for $250,000 and you go to sell in several years. If you're a married couple, you get $500,000 capital gains tax free. If you're a single person individual, you get $250,000 capital gains tax free. And if you are, let's say, now at a value of $1 million and you were to go sell that property you bought for $250,000, you'd have a gain of $250,000 as a married person, or $725,000. Let's see,
$500,000 for a single.
Exactly.
Yeah.
So it's $500,000 gain. Now, if you die without selling the property, your heirs receive that property, and there's a step up in basis at time of death, meaning that they would pay zero in capital gains tax. And then they also don't have to pay what they call the death tax or the estate tax, which is sheltered, you said, up to $15 million per individual.
That's right.
So this is a way to plan to pay less tax, is having your heirs receive that property at time of death. And yes, there would be a step up in their property tax basis to fair market value. However, you'd also have the step up in the capital gains tax. And so you look at the difference in the capital gains tax versus what you'd be saving in property tax, and you probably save like $300,000 on your capital gains tax bill, and your property tax bill could go up maybe 3x from, $4,000 to maybe $10,000.
Right.
Something like that.
It's a much better savings to receive that capital gain step up, even if you're not sure that you're going to sell. You can reset depreciation schedules, etc. So it's much better to have that flexibility of a full step up in basis, is what we call it, when it's inherited, versus simply focused on the property taxes. Property taxes are important because they go forever, right? So, as far as we know, they're going to have them, and you're going to pay them for many, many years. So it's worthy to try to keep those as low as you can. But if it's between the two, for your heirs' sake, inheriting a full step up in basis is going to be better than simply protecting the property taxes.
Yeah. Okay. Now, what is like the craziest thing you've ever seen happen in a probate situation? Have you had any crazy stories that you can share?
Oh gosh. I have one. I have a personal experience with a personally experienced situation where, and I'll tell you one that wasn't my case, but it was a colleague's case. But one of my first probates was a situation where a gentleman was driving down South Bay Boulevard between Morro Bay and Los Osos, and he had a heart attack on the drive, tragically, and he had a head-on collision with a bus. And then the bus tumbled down into the estuary. So the gentleman died from the heart attack or on impact. But so we probated his estate for the family. but it turned out that he was a hoarder. So we had to go to his house in Cambria and try to find important records, because his family, he was the married into the family, and no one knew what his financial situation was. They just knew that he had tremendous wealth, they thought. And so we went to his home, and boxes were piled to the ceiling. And this wasn't like just normal things. This was LLC paperwork and trusts from the East Coast that were 50 and 60 and 70 years old, and parents' estate documents. And so it turned out that he was trustee of his parents' trust. His parents had a yacht in the Caribbean. They had property in Manhattan. They had property in California. They had storage facilities full of collectibles. And he had spent his life basically just living off of their trust, with no records that anybody could decipher. So we were there personally right after he passed away, digging through boxes and just pulling out old operating agreements and pulling out old tax returns on entities that he'd created and then dissolved and then replaced with new ones. And it became this thing where I would bring back trash bags full of these records to our office to then sift through to try to find a needle in a haystack. And it was a fascinating situation. Meanwhile, the people that were on the bus all sued his estate.
Oh my gosh.
And so now we had 4 or 5 different attorneys all suing the estate. His successor trustee ended up being was the dean of a law school on the East Coast and had been on their Supreme Court, of a state on the East Coast. And so it became just an absolute convoluted, insane case where we, the final step was a mediation here in town, actually attended by 10 different parties, almost all of them in different states, all litigating against the same estate. So it was a fascinating first foray into trusts and estates work. I have a colleague that did a probate of Tupac's estate.
Wow.
The rapper. And his mother was his heir at law. He didn't have any children. And there were other people that came forward, but they were disqualified because he didn't have an estate plan. So it was going to pass like an heirs at law, which he didn't have children, so it was going to go to his mom. But it was also then hypothetically would go to his father. So the mother told the attorney, we don't know who the father is, or it's not this person. And somebody came forward to the attorney and said, no, I'm Tupac's father.
Oh, wow.
And they said, no way, we're going to bring you in for a paternity test. We don't believe it. And the mom said, no way, it's not him. It's not him. And so the attorney describes that he showed up to his deposition where they were going to take the paternity test. And in walks the absolute spitting image of Tupac.
Oh my God.
Just 20 years older.
Oh, no
and he
way.
said, as soon as he walked in, the attorney said, he just turned to his client and he said, we have to settle.
Oh, no.
So they did settle out of court. I don't know what the resolution was, but the way he described Tupac in a 20-year-older form, like strutting into the office.
Oh my gosh.
I will always kind of chuckle about. But that's one of the things that if you don't have an estate plan, you end up in situations like that.
Oh my goodness. And what a wild first encounter you had with that.
Yeah, which was another example that if the decedent hadn't done his own estate plan.
Mm-hmm.
And so part of that was all very public and very problematic because he had been in charge of his parents.
Mm-hmm.
He had a significant other he was concerned about, but he had never done his own plan.
Jeez, that is wild. So with that experience, I guess, what would you tell people that they need to do today?
Well, I do recognize that estate planning is sometimes it's going to help you, but you're doing it because it will help you. But lots of other times you're doing it in large part because it's a gift to the next people, your legacy. It's a gift to your family. It's a gift to your loved ones, people who are dependent on you. And so some people don't care. They just say, I'm not worried about those people. I'll just worry about me in the here and now. Mm-hmm. And so if that's your perspective, that's fine. But to most people, if they think about it, they go, well, this could benefit me if I'm in a problematic situation, and it will also definitely benefit the people that I care about. If that's you, if that's somebody listening, then they should consider at least biting the bullet and getting some real basic estate planning done at first. There's certain things that are available publicly online. Power of attorney, healthcare directive. California even publishes a will. Get those documents at least in place so that you have the real basics covered. Or talk to an estate planning attorney about doing, what we would usually call a complete estate plan, something that's going to cover all the areas of your life.
Totally. That's a good point, because we are real estate brokers. We primarily focus on the real estate component, which does get pulled into probate and trusts and issues that come up like that. But talk to us a little bit more about like the healthcare directive, and like, why would someone want to set that up? What's the benefit to them now to have like a healthcare directive set up?
Yeah, well, healthcare and financial power of attorney, both of them are documents that you create for you, and you're saying, if I'm in an emergency, or if I'm in a situation where I need help, I'm pre-designating who those people are that can come in and help me. And so whether that's your spouse, your parents, your children, or anybody in between, you're establishing in advance who I think is the right person to speak for me, advocate for me, be at the bedside in the hospital, yelling about why I need the surgery or don't. And then you're also able to make some decisions in advance so that the burden of having to guess about how you feel about really tough situation, like, gosh, what if I'm in a coma and it doesn't look like I'm coming back? Making that decision for your family or your loved ones in advance can be a real gift, because it takes some of that burden off of other people trying to guess what you felt or how you felt about it. So power of attorney and advanced healthcare directive are really important for that. They come in and they help you by naming someone who could be you, speak for you, carry out, if it's a financial power of attorney, carry out acts for you. They're going to help you in those emergency situations. And they're literally, an attorney can prepare a great one. I think we prepare great ones, but they're literally freely available. If you just search Advanced Healthcare Directive, California, statutory form, you'll see one that's free. It's right there in the probate code. And so it's widely available to download and fill out. Or same thing, if you do one for power of attorney, California statutory form, you'll see one widely available because it's printed in the probate code. So there's no excuse for anybody to not have those two documents, and everyone should have those two documents just in case. They don't get used most of the time, but in those situations where they're needed, they're so helpful.
Yeah. An example in real estate we will see is you need a power of attorney set up before, for situations like this. Let's say husband, wife, married, long time, and all of a sudden wife starts to experience early onset dementia, and her mind is starting to go, and she's not able to make cognitive decisions anymore. And so let's say husband and wife, they're like, okay, we've got a lot of medical bills starting to mount. We've got this big house. We don't need this big house anymore. We want to downsize. We want to liquidate, get our equity out, use that for medical or whatever else there could be. Well, if it comes down to we want to sign a listing agreement, but she doesn't have all of her faculties about her, she's unable to sign that listing agreement. And so what would the process be for that family to try to go and get a conservatorship set up and list of house?
You've experienced that. It's a very tough alternative, because if you don't have that document, which was a simple document that was very affordable, if you don't have that document in place, that power of attorney, then you do need to go to court, and you need to get usually a full conservatorship established, which is a legal proceeding where an adult says, I'd like to be able to make the decisions for another adult, and take away their authority to make their own decisions. And because that's a pretty dramatic thing to ask for, I want to make your decisions for you, It comes with a rigorous court scrutiny and a lot of documents that have to get filed. And it's an expensive process. We do conservatorships where my firm does. We are court-appointed counsel for conservatorships as well, where we're one of the handful of firms that have volunteered to be on the list because we're qualified. We've done enough of them that we know what we're doing, I guess. So we're one of the people they can pick. But the process is expensive. It's time consuming. And then even after it's established and folks then say, okay, great, I can sell the house. I got my conservatorship. That's not the end by any means. It's now just starting a new process of having to manage the conservatorship and do accountings and file things with the court at the right time. Things that, again, are tough to do correctly and can be very expensive and time consuming. So a conservatorship's a tough thing to have to go through and something that's worth trying to avoid if you can.
Yeah. All fixable by setting up a durable power of attorney.
Yeah, simple document.
Which you could do in a full estate plan.
Yep, definitely.
So when it comes to that conservatorship, do you see that mostly it's because of like dementia or like old age type symptoms, or can those conservatorships be applied for if you have a sibling who's like a drug addict and, you know, struggling to provide and take care of themselves? Can a conservatorship be set up in that situation, or is that, no, it's too far gone, the courts wouldn't support that?
It's expressly allowed for people with substance abuse, for alcoholism is what's in the code. It's an old code section. So it's available for substance abuse. It's not typically used because people with conservatorship still, it doesn't provide, like the police don't show up and handcuff the person and say, sorry, your conservator says you can't be out here tonight. You have to go back home. Like it's a process where it does require still a conservatee to be somewhat malleable to the process. Like they have to be responsive to the help. So it's not used frequently for substance abuse, though it can be. It is frequently used for people where they have a sibling who's maybe disabled. You know, maybe they're born developmentally disabled, or maybe something happens to them, they become disabled. So it doesn't just have to be for your parents or someone elderly. It could certainly be for someone who's younger, or even someone who's coming of age. They've been under 18, so they've been a child of someone, so you can make legal decisions for them. Now all of a sudden they're 18, and the law presumes they should make their own legal decisions, but they're not able to. So those are the types of situations where they're used.
Yeah. What about if there is someone in your family that's struggling with drugs, addiction, what would you say would be the best practice for setting something up to make sure that they are provided for, taken care of, but don't destroy their lives?
Right. I strongly encourage people who are in that situation to consider a trust that has a trustee in charge of whatever share that person would receive, so that there is some other, whether that's another loving, caring family member, or whether that's a third party who will be very professional and keep them at arm's length, so to speak. Not get personally involved, but be professional and able to dole out support as needed without giving your loved one with dependency issues, without giving them full access to the money. I've seen that work actually really well, where it really can be used to encourage that person to get their life back on the correct path, and give them the support they need to be in the right place with no support for bad behavior. And I've seen that really work well, helping people get their life, their associations back on the right track, so that then they know that there's something maybe there to support them as they try to either get clean or go back to school or invest in a new place to live. But I encourage folks to do a trust in those situations. Absolutely.
Totally. Now, what about when it comes to holding property? There's multiple ways in California to have your title held.
Sure.
There's community property, there's joint tenants, tenants in common. What would you say are some of the best methods for holding property given different scenarios?
Sure. Yeah. Well, if joint tenancy property is allowed in California, and you and I could hold property as joint tenants, and that means that whichever of us lives longer inherits the property from the other one. So if I pass away, my share goes to you. If you pass away, your share goes to me. That happens automatically. If we buy the property together, when that happens, then I'll get like a step up in basis of your half. If you buy the property and put me on title, I'll get a step up in basis when you pass away, but then I'll also get a reassessment because I wasn't the original owner. So that joint tenancy is a real basic way of holding property. That's not always everyone's intent, like that they want it to just automatically go to the person that they own it with. And they certainly don't always want the reassessment that comes with it if they don't know what they're doing when they're setting it up. So, but that is an option for real basic estate planning, that if you and I hold the property and our intent was always that whoever lived longer got it, that's a real basic thing you can do. In California, we have something called community property with right of survivorship. That's the best option for spouses if it's community property, because the survivor gets to receive it automatically, no court, no fancy stuff, but they also get a full basis step up versus joint tenancy where there's just a transfer of the deceased person's share and just that much of it gets a basis step up. So if two people are married, the husband, the spouse's community property with right of survivorship is usually a better option for them. Tenants in common just means that two people hold it together and that they don't have that automatic survivorship. And so whenever you have a group of people owning something, or whenever you have different percentages, you own 90, I own 10, that's going to be tenants in common, which just means multiple people on title to one property without a divided 90% share and a 10% share of the actual physical property. So tenants in common is the default if you don't say joint tenancy or you don't say community property with right of survivorship. Tenants in common can also be you and I both have it in our LLCs, or we both have it in our trust, each other's trust. That we can hold partial interest together, and even if they're entities, they would be tenants in common. So those are the three you'll see. You'll also see sometimes a married person as their sole and separate property. And that means that two people are married, one of them owns it, and it only belongs to them. And in those cases, that's usually like step one before they transfer it into their trust or something that will help with their estate plan. So if you're at home and you're trying to do some sort of quick estate planning, and you're just worried about your real estate, holding it in joint tenancy is at least a way to make sure that it doesn't go through a court proceeding.
Yes, the community property with right of survivorship, we sometimes call it the I love you forever way of holding property, because that goes to your wife, your spouse. You guys automatically pass it on, don't have to deal with all the probate issues, and you get that full step up. And so for tax planning purposes, that's a huge benefit.
Sure.
Whereas if you hold it and it's just standard community property,
if you don't designate that you want that right of survivorship and you just hold it spouses as community property, there actually has to be there might have to be a little court proceeding to
and
clear
so
that
it's
up.
less advantageous.
Yeah.
Could lead to some other issues. Could it then lead to them not receiving the property? It could maybe go to
possible if you just said husband and wife, for
husband
example.
and wife, community property.
No, it'll go to the survivor
Okay.
in that case, but they may have to do what's called a spousal property petition to show that they're the sole owner. And then that's not always what people want. They may not want it to go to just their spouse. They might want to go to their spouse and their children.
How did that one property end up going to the Marilyn Monroe's boyfriend, her director?
Yeah,
what was that one?
Oh yeah,
story
sure.
about?
Well, we do a presentation each year called Estate Planning Faux Pas of the Rich and Famous. My business partner and I do. We put it on for a couple local organizations. But one of the famous stories of an estate planning faux pas is Marilyn Monroe. She had a will, like a will that she had done, and she left 25%. I might be wrong on the percentages. My recollection is she left 25% to her acting coach, who was like an older guy. And that was her name, image, and likeness, 25% to him. And then she passed away tragically. And so he was to receive 25%. He married some young starlet. He was an older guy. And then he died within like 18 months of Marilyn Monroe's death. And so his estate plan passed entirely to his new spouse. And so his new spouse's family and her are now owning 25% of Marilyn Monroe, somebody they had no connection to. And so that estate stayed probated in New York City until like 10 years ago. And all the while, I think at its peak, it was making like $20 million a year. So Marilyn Monroe's acting coach's late in life wife's family was essentially probating Marilyn Monroe's name, image, and likeness for their benefit. And Marilyn Monroe had like a charitable intent. She had provided for some animal causes and such. Not at all what she would have intended. But because there was no estate plan for her to protect about what if, I don't know if the acting coach had an estate plan or not, but the default is going to be your spouse if you don't have any children.
Yeah. So that's why if you want to dictate who gets what, you got to get these estate plans set up. This is so important. And lastly, what would you say is like a risk that you see when it comes to estate planning? Because inheriting property or not can be very emotionally charged for families.
Yeah.
So what are some risks that could happen to potentially family members, siblings, or any of your loved ones? What do you most often see, and what's that usually look like?
Are you asking in any part of the process, or if people have a plan or not, or just across the whole spectrum?
Across the board.
Sure.
Death, inheritance.
Yeah.
It's a tough time for people. How do you see it backfiring or playing out in regards to the relationships of the loved ones that are left?
I mean, that you are a sensitive, smart guy. You've said it exactly right. It's a tough, charged, emotional time. And I referenced at the beginning when you asked about what are the mistakes that people make. Sometimes they don't choose the right person. And by that, I don't mean they picked a real bad person instead of a good person. I just mean maybe they picked somebody with not the right aptitude, or somebody who doesn't have the right mentality about taking it on, getting it done in an impartial way, getting through the process, keeping everybody apprised of what's going on. So I think that we see relationships fracture because usually there maybe be some issue, unspoken thing that's gone on between them in the past, and so there are already some charged feelings. I have a mediator colleague who says, it's not about what's happening in mom and dad's trust. It's about what they did at the dinner table 30 years before. So there's some disagreement between the siblings, and they're mad at each other from stuff they did when they were kids, and they're not necessarily mad about this, but now they're kind of taking it out on each other. So we see that sometimes. We see people, families where they empowered one sibling maybe over others, and that was just the wrong choice. Maybe they picked them because they were proximately close, they were nearer in proximity, but they weren't the right mentality to do the job. They didn't have the right attitude about rolling up your sleeves and trying to get through it. They had maybe too much of a take charge attitude where they don't care what anybody else thinks. They're just going to do it their way without getting the right advice or without taking other people into account. So those are the mistakes we see, and some of the problems we see is that it becomes very personal, and then it can become very petty. And usually with that, suddenly now it can become more expensive because the people aren't getting along, and maybe there's multiple lawyers involved. So lots of people get through the process just fine. They don't even talk to the attorney. They just work it out together. They get along great. Mom and dad did a great estate plan, so they don't have to worry about court proceedings and such. But when they come to us, we do tend to see sometimes those tougher situations where people aren't getting along.
Mm-hmm. And we've had it happen where some clients, their father passed away. There were 3 houses. The trustee came in right away, met with us. We signed 3 listing agreements, and we liquidated the entire portfolio within a matter of months.
Yeah.
And since they had the full authority to do so through the trust, and they didn't have to go through probate, it was a smooth process. Everyone received their inheritance. One of the grandsons went on to buy a house. Another one bought a boat. Another one paid off student loans. Everyone benefited. It was a huge, happy time for the whole family.
Right.
And then other times we have clients where they didn't have that trust set up, and it turns into a 6-year-long process going through probate, stressed out. The family becomes totally embittered and embattled against each other. They're estranged. They don't talk to each other. They have attorneys that have to communicate with either side because they don't even trust each other anymore from all the pettiness that has come about. And it becomes very costly and very emotionally taxing, way beyond just the amount of money they had to spend in attorney's fees and court time. So, Matt, in closing, what would you say is one piece of advice you'd encourage everyone in our audience right now who doesn't have a trust or a estate plan set up?
Well, that's a good question. I already hinted at it or even referenced it. First of all, at least clear the basic hurdle of getting your power of attorney and your advanced healthcare done, because it's easy. There's no excuse to not have it. 98% of the time, it's not necessary. But that 2% of the time, to know that you've done that and protected yourself or protected your family, having it done in the background will just give you a little bit of peace of mind. The next step I would think about is if it's not you, who would it be? Just to think about that question. If I couldn't take care of my life, who would do it? If I wasn't around to provide for those needing my assistance, who would provide for them? And if you think about that question, you might quickly realize, oh my gosh, I got to get a plan together. Or, oh my gosh, I've got such an obvious answer to that question. It feels like estate planning is this big, huge conundrum of too many moving parts. But the reality is, if I really think about it and I just answer those 2 questions, if it's not me, then who would it be? All of a sudden, it starts to feel really simple and clear. So I would say make sure you get those free things done at the minimum, just so you have them in place, you can have a little peace of mind. And then ask yourself those 2 kind of high-level questions. And if you think about it and it causes you some sort of anxiety about, gosh, if I wasn't around, who would do it? Then take the next step and relieve yourself of that anxiety by getting some sort of plan in place in advance.
Awesome. Well, Matt, thank you so much for coming on the show and having a conversation. If you want to get in touch with Matt, check out our description below. There'll be some details there, or send us a message. We're happy to put you guys directly in touch. And if you like this show, please like and subscribe. It helps more people like you find the content. So please like it, and then share this with somebody you care about. If they don't have a trust set up, or if they need an advanced healthcare directive set up, you want to share this with them so that way they can have that plan in place. So thank you all so much for tuning in, and we'll see you next time.